You know, it's the kind of story you hear all the time. A beautiful river view, a neighbor putting in a new pool, and of course, a fence. Seems like a classic neighborhood spat, right? But this one went all the way to a judge. And what it uncovered is a surprising legal truth that honestly affects millions of us who live in homeowners associations.
And it all boils down to this one really important question. What actually happens when your HOA's rules break the law? I mean, you've got this rule book for your little community. But what if one of those rules flies directly in the face of a city or county law? Who gets the final say? That's exactly what we're going to unpack here.
So, to really get a grip on this, we've got to go back to the beginning. Because this wasn't just some abstract legal argument. Nope, this was about a guy, his home, and something he really, really cared about.
So, meet Andrew Holzman. He's our homeowner. He lived in this community called Emerald Springs, and from his property, Lot 24, he had this absolutely incredible view of the Colorado River. I mean, it's the kind of thing you buy a house for, right? Something you definitely want to protect. But, well, that view was about to be in jeopardy. So the trouble started right next door, on Lot 23. His neighbors had big plans for talking new landscaping, a pool, even waterfalls, the whole shebang. But the part that really mattered to Mr. Holzman, the new fence that was going to go around it all. He was worried, and rightfully so, that this fence would pop up and completely block his amazing river view. Okay, so Mr. Holzman does exactly what you're supposed to do in this situation, right? He takes his concerns straight to the Homeowners Association. He'd even met with his neighbors before all this to try and work something out. But when the official HOA meeting finally happened, oh man, that's when things just got super confusing. So, picture this. It's June 21st, 2008. The board's having their meeting. And Mr. Holzman, he has to join by phone. Now, that might not sound like a big deal, but it's everything here. Because it means he literally can't see the plans they're all looking at. And what does the board do? They give this super vague, conditional approval. Nobody, especially Mr. Holzman, had a clue what that actually meant.
And if you think that was confusing, just wait. After the meeting, an email comes out from the HOA secretary, and it seems to confirm that, yeah, a plan was approved. It says plans were passed around for everyone at the meeting to see. Okay, seems clear enough, right?
Wrong. Just 2 hours later, another email lands from the exact same secretary. And this one says the board is still waiting for, get this, revised plans. So what is it? Is there an approved plan, or are they still waiting for one? This back and forth was the final straw for Mr. Holzman. He needed a straight answer, and it was clear the only way to get one was to take it to court.
And here's where the case gets really interesting. Because hiding underneath all this mess, the confusing meeting, the contradictory emails, there was a much simpler, much more fundamental conflict going on. We're talking about a head-on collision between the HOA's own rulebook and actual county law.
Okay, look at this. This is the heart of the whole problem. The Emerald Springs HOA rulebook, crystal clear. Fences near the river cannot be more than 4 feet tall, period. But the La Paz County ordinance was just as clear. Any fence around a swimming pool has to be a minimum of 5 feet tall, for safety. They were in total opposition. You literally could not follow both rules at the same time. Impossible.
So that leads to the million-dollar question, doesn't it? Which rule wins? Is it the private community agreement that Mr. Holzman was counting on, or is it the public safety law that the county was enforcing?
Well, this exact question ended up in front of an administrative law judge. Finally, all the he said, she said stuff about the meeting and the emails got pushed aside so they could focus on this one single, critical conflict of rules.
And the verdict? It was decisive. The judge ruled against Mr. Holzman. He sided with the Homeowners Association. The 5-foot fence was allowed to go up no matter what the HOA's own rulebook said. And the reason for this is the most important lesson in this whole story. And here it is, straight from the judge's mouth. Judge Kowal wrote that the HOA, quote, cannot be compelled to abide by provisions that are contrary to law. Think about that. He's saying the HOA wasn't just allowed to ignore its 4-foot rule, it was legally required to follow the county's 5-foot rule. The county ordinance wasn't just a suggestion, it was to law. So this whole saga in Arizona actually shines a light on a universal legal principle, one that applies to pretty much every single community association across the entire country. And it all comes down to a really clear hierarchy of rules. Yeah, the best way to think about it is like a pyramid. At the very top, the peak, you've got government law. That's your federal, state, and in this case, county laws.
the big stuff. Down a level from that, you've got the HOA's own governing documents, their CC&Rs. And then at the base, you have what individual homeowners can do. And the rule is super simple. Every level has to obey the level above it. An HOA rule just isn't valid if it breaks the law. End of story.
So what are the big takeaways for you here? Well, number one, public law always wins over private community rules. Number two, an HOA can't force you to do something that would make you break the law. That's just a non-starter. And probably the most practical piece of advice, if you're ever in a fight over an HOA rule that just seems off or totally unreasonable, your first step should be to check your local city or county ordinances. The answer might be sitting right there in black and white.
And that really leaves us with one final thought. You know, we all live by rules, written and unwritten. Mr. Holzman fought hard for a rule that was written down plain as day, but it just couldn't hold up against the law. It kind of makes you think, doesn't it? What are the rules that govern your community? And more importantly, are they even legal?